different kinds of meeting of the shareholders or members are. The first meeting of the members of public company is known as statutory meeting. Section 83(1) of the Companies Act, 1994 states as follows. Every company limited by shares and every company limited by guarantee and having shares capital shall, within a period of not less than 1 month and not more than 6 months from the date at which the company is entitled to commence business, hold a general meeting of the members of the company. In this act, such meeting is referred to as the statutory meeting. As per Section 83(12), nothing of Section 83 of the Companies Act shall apply to a private company. This means that only the public limited company is required to hold the statutory meeting only once during its lifetime. Section 83(2) of the Companies Act, 1994 states as follows. The Board of Directors shall, in accordance with other provisions of this Act, prepare a report, in this act referred to as statutory report, and shall at least 21 days before the day on which the statutory meeting is to be held, forward the report to every member of the company. Provided that if the report is forwarded later than the time as is required above, it shall, notwithstanding that fact, be deemed to have been duly forwarded if any member entitled to attend and vote at the meeting does not object to such forwarding. Certification of statutory report. Section 83(4) of the Companies Act, 1994 states as follows. The statutory report shall be certified as correct by not less than 2 directors of the company, one of whom shall be the managing director where there is one. As per Section 83(5) of the Companies Act, 1994, so far as the report relates to the shares allotted by the company, the cash received in respect of such shares and the receipts and payments of the company, be certified by the auditors of the company regarding its correctness. Duties of the Secretary relating to statutory meeting. The company secretary has to perform the following duties relating to statutory meeting. 1. Collect all information required to fill up the statutory report as per prescribed Form 7. 2. Comply with the requirements of Section 83 of the Companies Act, 1994. 3. Prepare the statutory report in consultation with the chairman and the managing director, if there is any. Organize a board meeting for approval of the draft statutory report and fixation of date, time and venue of statutory meeting. Obtain certification of auditors and 2 directors, including the managing director, if any. Forward copy of the report to every member of the company at least 21 days before the day of statutory meeting. File a copy of the statutory report with the Registrar of Joint Stock Companies immediately after the statutory meeting. Prepare and produce a complete list of names and addresses of members of the company and number of shares held by each member. Record the minutes of the proceedings of statutory meeting in the members' minute book. Keep copies of all contracts for inspection. B. Annual General Meeting. As per Section 81 of the Companies Act, 1994, the followings are applicable with regard to Annual General Meeting. Every company shall hold a general meeting as its annual general meeting in each year of the Gregorian calendar. Not more than 15 months shall elapse between the date of one annual general meeting of a company and that of the next. The first annual general meeting of a company may be held within a period of 18 months from the date of its incorporation, and if such general meeting is held within that period, it shall not be necessary for the company to hold any annual general meeting in the year of its incorporation or in the following year. The registrar may, on an application made by a company within 30 days from the date of expiry of the period specified for holding the annual general meeting, not being the first annual general meeting, extend the time by a period not exceeding 90 days or not. exceeding December 31st of the calendar year in relation to which the annual general meeting is required to be held, whichever is earlier. If a company defaults in complying with the provisions as mentioned above, the court may, on the application of any member of the company, call or direct the calling of a general meeting of the company and give such ancillary or consequential direction as the court thinks expedient in relation to the calling, holding, and conducting the meeting. Section 183(1) of the Companies Act, 1994 states the followings. The Board of Directors of every company shall, at every annual general meeting held in pursuance of Section 81, lay before the company a balance sheet together with the profit and loss account, or in the case of a company not trading for profit, an income and expenditure account for the period specified in subsection 2 of this section. Section 183(2) of the Companies Act, 1994 states the followings. The said profit and loss account or the income and expenditure account shall be prepared for the following period, namely, in the case of the first general meeting for the period beginning with the date of incorporation of the company and ending on a date which is within 9 months preceding the date of the meeting, and in the case of subsequent annual general meeting, for the period beginning with the date immediately after last account and ending on a date which is a date within 9 months preceding such meeting, or in the case of a company carrying or business or having interest outside Bangladesh, a date within 12 months preceding the date of such meeting, or in case where an extension of time has been granted for holding the meeting under Section 81, a date within the said 9 or 12 months, as the case may be, preceding the date of holding such meeting under that section, provided that the register may, on an application being made to before the expiry of the said 9 or 12 months, extended the period by a period not exceeding 3 months. According to Section 183(4), the accounts shall have to be prepared for one financial year which may be more or less than a calendar year but shall not exceed 15 months except when the registrar grants extension up to 18 months. Again, according to Section 183(2), the accounts which will be presented to AGM will relate to a period not beyond 9 months preceding to the date of AGM or 12 months for companies having business or interest outside Bangladesh. Factors affecting the counting of interval between 2 consecutive AGMs when the court condones delay. When the court condones delay in holding the AGM according to Sector 81(1), the time frame described in that subsection for holding AGM becomes ineffective. The new schedule starts from the date of holding the AGM as per order of the court, and the 15 months interval should be counted from that date. When the registrar extends the time for presentation of accounts in the AGM as well as the time for preparation of accounts, therefore, in special cases, the registrar can extend the time under Sector 183(4) up to 18 months. According to Sector 183, accounts shall have to submit before the AGM. The accounts shall relate to a period not before 9 months of the AGM, i.e. within a period prescribed in Section 81, whenever the AGM is held, within 18 months of incorporation or within 15 months of preceding AGM. The object of convening AGM is to consider the balance sheet and profit and loss account. Accounts have not been prepared or audit of accounts has not been completed cannot be valid reason for not convening the ordinary general meeting. Notice of AGM. According to Sector 85(1)(a), 21 days notice in writing shall have to be given for AGM notwithstanding any provision in the Articles of Association. However, an AGM may be convened with the consent of all the members entitled to receive the notice of the meeting by a shorter notice as they think fit. Sector 85(1)(a)(i). Notice of the meeting of a company with a statement of the business to be transacted at the meeting shall be served on every member in a manner in which notices are required to be served by Schedule I, but accidental omission to give notice to, or the non-receipt of notice by any members shall not invalidate the proceedings at any meeting. If the articles make clear provision regarding business to be transacted at AGM, notice need not describe the business to be transacted at AGM. Where a director does not hold any share, he is not entitled to notice of general meeting. Following new clauses have been inserted by the amendment dated September 7, 2020. 85. F. All proceedings taken at the extraordinary general meeting shall be deemed to be special agenda/resolution. Provided that the sanction of dividend, bonus shares, approval of audit report, reports of directors and auditors, periodical retirement of directors and fixation of remuneration of auditors shall not be treated as special agenda/resolution. G. If any special agenda discussed in the special general meeting is supported by any document, the same shall be clearly mentioned in the notice of the time and place of the visit, and H. Shareholders holding a minimum of 5% share capital can propose the agenda in the AGM/annual general meeting of the company. According to Section 84, 1, notwithstanding anything contained in the articles, the directors of a company, having share capital shall on the requisition of the holders of not less than 1/10 on the issued share capital of the company upon which all calls or other sums then due have been paid, forthwith proceed to call an extraordinary general meeting of the company, and in the case of a company not having a share capital, the directors thereof shall call such meeting on the requisition of such members as have on the date of submitting the requisition not less than 1/10 of the total voting power in relation to the issues on which the meeting is called. According to Section 84, 3, the directors shall call the meeting within 21 days from the date of deposit of the requisition, which is to be held within 45 days from the date of deposit of the requisition. Otherwise, the requisitionists themselves or majority of them may convene the meeting within 3 months from the date of the deposit of the requisition. The directors may, whenever they think fit, call an extraordinary general meeting, and extraordinary general meetings shall also be called on such requisition, or in default, may be called by such requisitionists, as provided by Section 84 of the Companies Act, 1994. If at any time there are not within Bangladesh sufficient directors capable of acting to form a quorum, any director or any 2 members of the company may call an extraordinary general meeting in the same manner as nearly as possible as that in which meeting may be called by the directors. Proceedings at general meeting. All business shall be deemed special that is transacted at an extraordinary meeting, and all that is transacted at an ordinary meeting are sanctioning a dividend, the consideration of the accounts, balance sheets and the ordinary report of the directors and auditors, the election of directors and other officers in the place of those retiring by rotation, and the fixing of the remuneration of the auditors. No business shall be transacted at any general meeting unless a quorum of members is present at the time when the meeting proceeds to business, save as therein otherwise provided. 2 members in the case of a private company and 5 members in the case of any other company, personally present shall form a quorum. If within half an hour from the time appointed for the meeting a quorum is not present, the meeting, if called upon the requisition of members, shall be dissolved. In any other case, it shall stand adjourned to the same day in the next week at the same time and place, and, if at the adjourned meeting a quorum is not present within half an hour from the time appointed for the meeting, the members present shall be a quorum. The chairman selected among them by the board of directors shall preside as chairman at every general meeting of the company, provided that the chairman and the managing director shall not be the same person. If there is no such chairman, or if at any meeting he is not present within 30 minutes after the time appointed for holding the meeting, or is unwilling to act as chairman, the members present shall choose someone of their number to be chairman. The chairman may, with the consent of any meeting at which a quorum is present, and shall, if so directed by the meeting, adjourn the meeting from time to time and from place, but no business shall be transacted at any adjourned meeting other than the business left unfinished at the meeting from which the adjournment took place. When a meeting is adjourned for 10 days or more, notice of the adjourned meeting shall be given as in the case of an original meeting. Save. As aforesaid, it shall not be necessary to give any notice of an adjournment or of the business to be transacted at an adjourned meeting. At any general meeting a resolution put to the vote of the meeting shall be decided on a show of hands unless a poll is before or on the declaration of the result of the show of hands, demanded, in accordance with the provisions of Clause C of subsection 1 of Section 85 of the Companies Act 1994, and unless a poll is so demanded, a declaration by the chairman that a resolution has, on a show of hands, been carried unanimously, or by a particular majority, or lost, and an entry to that effect in the book of proceeding of the company shall be conclusive evidence of the fact, without proof of the number or proportion of the votes recorded in favor of, or against, that resolution. If a poll is duly demanded, it shall be taken in such manner as the chairman directs, and the result of the poll shall be deemed to be the resolution of the meeting at which the poll was demanded. In the case of an equality of votes, whether on a show of hands or on a poll, the chairman of the meeting at which the show of hand takes place, or at which the poll is demanded, shall be entitled to a second or casting vote. A poll demanded on the election of a chairman or on a question of adjournment shall be taken forthwith. A poll demanded on any other question shall be taken at such time as the chairman of the meeting directs. Votes of members. On a show of hands, every member present in person shall have one vote. On a poll, every member shall have one vote in respect of each share or each 100 taka of stock held by him. In the case of joint holders, the vote of the senior who tenders a vote whether in person or by proxy shall be accepted to the exclusion of the votes of the other joint holders, and for this purpose seniority shall be determined by the order in which the name stands in the register of members. A member of unsound mind, or in respect of whom an order has been made by any court having jurisdiction in lunacy, may vote, whether on a show of hands or on a poll, by his committee or other legal guardian, and any such committee or guardian may, on a poll, vote by proxy. No member shall be entitled to vote at any general meeting unless all calls or other sums presently payable by him in respect of shares in the company have been paid. On a poll, votes may be given either personally or by proxy, provided that no company shall vote by proxy as long as a resolution of its directors in accordance with the provisions of Section 86 of the Companies Act, 1994, is in force. The instrument appointing a proxy shall be in writing under the hand or the appointer or of his attorney duly authorized in writing, or, if the appointer is a corporation, either under the common seal, or under the hand of an officer or attorney so authorized. General Rules of Members' Meeting. Notice to be issued on the authority specified in the articles and served in the prescribed manner. Notice to be given to every person entitled to receive notice. Though notice need not be given if all entitled to attend are present, yet such notice is issued to comply with formalities. Absence from the recorded address of a person entitled to attend a meeting is not good reason for not serving the notice. Though one member may have informed the company that he is unable to remain present, yet notice shall have to be given. The proper period of meeting, date, hour, day, and place of meeting must be stated in notice. As per Sections 78 and 79, notice must contain the name of the company. The nature of the business to be transacted must be disclosed in notice. The validity of resolution passed in a meeting may be questioned if the notice were faulty. It is essential that notice must be frank, open, clear, satisfactory, and free from trickiness. Notice must not be contingent or conditional. It must be absolute. Notice of adjourned meeting need not be given if the meeting adjourned for less than 10 days, Regulation 56, Schedule 1. In spite of the non-compliance of requirements of Articles and Act, if every member is present at the meeting and any resolution passed unanimously which is not ultra vires the company, is valid and binding on the company, irrespective of what notice, if any, of the meeting was given. Quorum at members' meeting. Quorum is the minimum number of members required to be present personally for conducting a valid meeting, provided proxy towards quorum may be counted if permitted by the Articles of Association. Quorum as per Articles. The Articles usually contain a provision regarding quorum that must be present to start the business at a meeting. If the Articles do not provide anything for the quorum, provisions of the Act shall apply. The articles may provide expressly or by implication that quorum need not be present throughout the meeting. The articles may also provide special majority being less than quorum for an adjourned meeting. Section 85, 2, of the Companies Act, 1994 authorizes the articles to make provision for quorum. In absence of specific provisions in the articles of a company, the provisions as mentioned in Section 85, 2, of the Companies Act, 1994 shall be applicable. 2 or more members holding not less than 1/10 or the total share capital paid up, or, if the company has not a share capital, not less than 5% in number of the members of the company may call a meeting. In the case of a private company whose number of members does not exceed 6, 2 members, and if such number exceeds 6, 3 members, and in the case of any other company, 5 members personally present shall be a quorum. Any member elected by the members present at a meeting may be chairman thereof. In the case of company originally having a share capital, every member shall have 1 vote in respect of each share or each 100 taka of stock held by him, and in any other case, every member shall have 1 vote. On a poll, votes may be given either personally or by proxy. The instrument appointing a proxy shall be in writing under the hand or the appointer or of his attorney duly authorized in writing, or if the appointer is a corporation or a company, either under seal or under the hands of an officer or an attorney duly authorized. Provided that the appointment of proxy shall not be allowed in case of companies formed under Section 28 and a proxy may or may not be a member of the company. Regulation 52, not compulsory as per SEC 17, 2, of Schedule 1 of the Companies Act, 1994 provides the followings with regard to quorum. Public company. 5 members present in person are required to form quorum for general meeting to pass ordinary resolution or special resolution or extraordinary resolution. Private company. 2 members present in person are required to form quorum for general meeting to pass ordinary, special, extraordinary resolution. Waiting time of quorum. The articles of the company usually provide as to how long from the appointed time the members are required to wait for the quorum, and if no quorum is present within that time, what will happen to the meeting. In absence of any such provision in the articles, the following will be applicable. Regulation 53 of Schedule 1. If within half an hour from the time appointed for the meeting a quorum is not present, the meeting, if called upon the requisition of members, shall be dissolved. In any other case, it shall stand adjourned to the same day in the next week at the same time and place, and if at the adjourned meeting a quorum is not present within half an hour from the time appointed for the meeting, the members present shall be quorum. Regulation 54 of Schedule 1. The Board of Directors shall select one of their members as its chairman who shall preside at every general meeting of the company. Provided that the chairman and the managing director shall not be the same person. Regulation 55 of Schedule 1. If at any meeting the chairman is not present within 30 minutes after the time appointed for holding the meeting, the members present shall choose someone of their number to the chairman. Effect of absence of quorum within waiting time. If within 30 minutes of the time appointed for meeting or such other time as may be mentioned in the articles, the quorum is not present, the meeting shall stand adjourned to the same time, day and place till next week or as per provisions of the articles. A meeting called upon the requisition of members shall stand dissolved if quorum is not present within the waiting time. Quorum of extraordinary general meeting. The quorums required by the provisions of Articles of Association usually regulate convening an extraordinary general meeting. As per Section 87, 1, 3/4 majority of the members entitled to vote present in person or by proxies are required to pass an extraordinary resolution. Unless the articles provide otherwise, quorum as per Schedule 1 shall be required to conduct extraordinary general meeting. Counting of representative towards quorum. Section 86 of the Companies Act, 1994, a company which is a member of another company may by resolution of the directors authorize any of its official or any other person to act as its representative at any meeting of that other company, and the person so authorized be entitled to exercise the same powers on behalf of the company which he represents as if he were an individual shareholder of that other company. Quorum must be effective. Mere personal presence is not enough to form quorum. The quorum must be effective members qualified to vote. Therefore, a member not qualified to vote shall not be counted for quorum. Authentication of accounts. 1. According to Companies Act, the balance sheet, profit and loss account or income and expenditure account shall be signed on behalf of the Board of Directors. I. In case of a banking company, by the manager or managing agent, if any in 3 directors where the number of directors is more than 3 or by all the directors, if their number is not more than 3, Sector 189, 1. 2. In case of any other company, by its managing agent, manager, or secretary, if any and by not less than 2 directors of the company and one of whom shall be the managing director where there is 1, Sector 189, 1. 2. When the total number of directors of the company for the time being in Bangladesh is less than the number of directors whose signatures are required by clause I and 2 above, then by all the directors in Bangladesh, or if there is only one director in Bangladesh, by such director, but in such a case, a statement by such director or directors explaining the reasons for non-compliance of provision of Section 189, 1, shall have to be attached. 3. The balance sheet, profit and loss account or income and expenditure account shall be audited. The auditor's report shall be attached thereto, Sector 183, 3. Authentication of accounts of banking company as per Banking Companies Act. According to Section 38, 2, of Banking Companies Act 1991, the balance sheet, profit and loss account and financial report shall be signed by. In the case of banking company incorporated in Bangladesh by the managing director or the chief executive of the company and where there are more than 3 directors of the company, by at least 3 of those directors, or where there are not more than 3 directors, by all the directors, and in the case of a banking company incorporated outside Bangladesh, by the manager or agent of the principal office of the company in Bangladesh and by another officer next in seniority to the manager or agent. Board's Report, Authentication, Consequences of Default. As per Section 184, 1, there shall be attached to every balance sheet laid before a company in the general meeting a report by its Board of Directors which shall include the state of the company's affairs, the amount, if any, which the Board proposes to carry to any reserve in such balance sheet, material changes and commitments, if any, affecting the position of the company which has occurred between the end of the financial year of the company to which the balance sheet is related and the date of the report. As per Section 184, 1, the Board's report and any addendum thereto shall be signed by the Chairman if authorized in that behalf by the Board or by the Directors as required to authenticate accounts of the company. Filing of Annual List of Members and Summary. As per Section 36, 1, every company having share capital shall within 18 months from its incorporation and thereafter once at least in every year make a list of all persons who on the day of the first or only ordinary general meeting in the year are members of the company, and of all persons who have ceased to be members since the date of last return or in case of first return, since the date of incorporation of the company. Section 36, 2. The following shall be stated in the list, namely: A. The names, addresses, nationality and occupation of all past and present members. B. The number of shares held by each of the existing members at the date of return specifying the shares transferred since the date of last return or, in the case of first return, since the date of incorporation, by persons who are still members and by persons who have ceased to be members respectively and also the dates of registration of such transfer, and C. A summary distinguish between shares issued for cash and shares issued as fully or partly paid up otherwise than in cash and specifying the following. D. The amount of the share capital of the company, and the number of the shares into which it is divided. E. The number of shares taken from the commencement of the company up to the date of the return. F. The amount called up on each share. G. The total amount of calls received. H. The total amount of calls unpaid. I. J. The total amount of the sums, if any, paid by way of commission in respect of any share or debentures, or allowed by way of discount, in respect of any shares or debentures, since the date of the last return or so much thereof as has not been written of at the date of the return. The total number of shares forfeited. K. The total amount of shares or stock for which share warrants are outstanding at the date of the last return. L. The total amount of share warrants issued and surrendered respectively since the date of the last return. M. The latest date on which the general meeting should have been held and whether it was actually so held. N. The number of shares or amount of stock compromised in each share warrant. O. The names and address of the person who at the date of return are the directors of the company and of the persons, if any, who at the said date are the managers, managing agents or auditors of the company, and the changes in the personnel of the directors, manager, managing agents since the last return together with the dates on which the tool place, and P. The total amount of debt due from the company in respect of all mortgage and charges which are required to be registered with the register under this Act. As per Section 36, 3. The list and summary under Section 36 shall be contained in a separate part of the Register of Members and shall be completed within 21 days from the date of first or ordinary general meeting in that year. B. Have to be filed with the registrar. C. To be signed by the managing director and one director, or if there is no managing director, by a director and managing agent or manager or secretary. A private limited company shall have to submit a certificate stating that it has not issued any invitation to the public to subscribe for any shares or debentures. The return in the form set out in Schedule X of the Act cannot be filed without holding the general meeting. Dividends and reserve. Regulation 96 of Schedule I. The company in general meeting may declare dividends, but no dividends shall exceed the amount recommended by the directors. Dividend shall be paid within 2 months from the date of its declaration, provided that the period of 2 months shall not apply in case where there is a dispute regarding the right to receive the payment, or the dividend has been lawfully adjusted by the company against any sum due to it from the shareholder. However, Clause 28 of Dhaka Stock Exchange, Listing, Regulations, 2015 states the followings. 1. The issuer of listed securities shall, within 30 days of declaration or approval, as the case may be, based on the written option collected from the securities holder concerned, pay off the dividend. Through transfer of cash dividend to the bank of the securities holder for depositing into the securities holder's account, provided that the securities holder will bear the applicable service charge, if any, of the securities holder's banker, and also that the issuer shall simultaneously issue a letter of intimation to the securities holder containing, among others, the amount of tax deducted at source, if any, the date and amount remitted with details of the bank through and to which bank such remittance has been effected, or through issuance of cash dividend warrant in the name and address of the securities holder concerned as provided in the beneficial owners, BO, account set up in case of dematerialized securities, or as provided by the securities holder in case of paper securities. B. Through transfer of stock dividend into the beneficial owners, BO, account of the shareholder in case of dematerialized share, or through issuance and delivery of the share certificate to the shareholder in case of paper share. 2. An issuer of listed securities, which makes a default in complying with the provision of Sub-Regulation 1. Respective director/officer shall be jointly and severally liable to pay to the exchange a penalty of Taka 5,000.00, only for every day during the default continues. provided that the exchange shall notify the fact of such default and the name of defaulting issuer by notice or through online news of the exchange. Provided further that any action under this sub-regulation, 2, shall be without prejudice to the action or steps taken by any other person or authority. Regulation 97 and 98 of Schedule I. The directors may from time to time pay to the members such interim dividends as appear to the directors to be justified by the profits of the company. No dividends shall be paid otherwise than out of profits of the year or any other undistributed profits. Regulation 99 of Schedule I, subject to the rights of persons, if any, entitled to shares with special rights as to dividends. All dividends shall be declared and paid according to the amounts paid on the shares, but if and so long as nothing is paid upon any of the shares in the company, dividends may be declared and paid according to the amounts of the shares. No amount paid on a share in advance of calls shall, while carrying interest, be treated for the purposes of this article as paid on the share. Regulation 100 of Schedule I. The directors may, before recommending any dividend, set aside out of the profits of the company such sums as they think proper as a reserve or reserves which shall, at the discretion of the directors, be applicable for meeting contingencies, or for equalizing dividends, or for any other purpose to which the profits of the company may be properly applied, and pending such application may, at the like discretion either be employed in the business of the company or be invested in such investments, other than shares of the company, as the directors may from time to time think fit. Regulation 101 of Schedule I. If several persons are registered as joint holders of any share, any one of them may give effectual receipts for any dividend payable on the share. Notice of any dividend that may have been declared shall be given in manner hereinafter mentioned to the persons entitled to share therein. No dividend shall bear interest against the company.